Thanks, Susan. As she said, my name is Blake Bailey with Phelps Dunbar. Joe Reimer is my partner that handles and heads up our commercial transactional practice. I do the commercial litigation work, so I should remember that. Claudine Jackson, who is with us, heads up our employment work out of our Fort Worth office, who was on your roster for today as well. Many of you do know Claudine as well. Unfortunately, she ended up with a fever the night before last, and we banned her from coming. But she's probably watching along with the rest of the ACC folks. But we really do appreciate the opportunity to sponsor the ACC. We're big fans across the offices. We do a lot of work from all the way across the Gulf Coast region, from Texas down through Houston, of course our Fort Worth office, and through New Orleans, Gulfport, Mississippi, on over to Tampa, Florida. COVID's been good for us because it's given us lots of opportunities. Our biggest expansion that our firm engaged in recently is we merged with another 100-plus-year-old firm out of Birmingham, Alabama, the Cabinus firm. You always have to be careful. They sound like they're really mellow guys and get the letters right. We often refer to them as cannabis, but that's not a good idea. They're now Phelps Dunbar, so we've now got a major office in Birmingham as well, which I think is our 12th office when you count London as well. So anyway, we're here. We're glad that Papa Brothers opens up on lunchtime just for us and just for y'all. We'd like to try and do it here as often as we can, as many of you know from past years. So we're here to talk about ethics. I'm not sure our marketing people got that quite right to say Phelps Jeopardy. Phelps keeps you out of Jeopardy. And this is more styled towards ethics Jeopardy. So, there we go. There's 3 topics for you today: social media, corporate transactions and related matters, and cause for insomnia, which will send you off for the new year in the right mood. So, it can't be law school without a story problem, right? You are the general counsel of the North Pole, Inc. Anonymous posts began to appear on social media under the hashtag "The North Pole is Sexist," alleging North Pole C-suite executives have made sexist comments on their private social media accounts. So we're going to do a series of questions on that, and this is the audience participation part of this. Oops. Oh, no. Now, if anybody doesn't get that right at this point, let me see if we can get here. I don't know that my clicker's reaching, is it? Do you want to take us to the next slide? There we go. So, when the story hits the press, you should investigate the allegations yourself. Now, who read fast enough to see? All the way in the back. Yes. Who says no? All right. The answer, of course, is the lawyerly answer: probably not. Now, we know you're going to be forced to answer these questions and do the investigations in-house counsel because they're not going to let you just refer it out. So if we go to the next slide, here's some factors to consider. This is why we say probably not. When you're making the decision and your owner, your president of the company comes and says, get to the bottom of this and tell me what's going on. Here's some considerations about whether you want to take it on yourself or not. Look at the seniority of who is being accused and is likely subject to the investigation. This puts you in a horrible spot as in-house counsel, as you all know, when the president of the company says, fix this for me. And you have to do an investigation of the head of the company. Remember, your client, and you all know this, your client is the organization. It's not the individual owners, and this is where you get in trouble. Look at the potential financial exposure to the company. The subject matter, is this going to lead to law enforcement activity? Now, sexist comments didn't used to lead to law enforcement. Now, any opportunity the government has to come after you, they're going to, whether it's in the media or with actual litigation. The need for actual or perceived independent review. You're seeing all the time now, even CNN recently with the Chris Cuomo situation. First thing they did was say, we're waiting for our outside counsel's report. It gives you protection too. And lastly, the attorney-client privilege is so hugely important when you're dealing with the company. And we'll deal with that a lot more as it comes up here as we go through. But these are some considerations to look at to figure out what you want to do and whether or not to send this to outside counsel. So all the way in the back. All right.
Prize.
See, we did come with prizes. You're not getting the $200, but we do have prizes to encourage the participation. All right. So the $400 question, which won't be quite worth $400. If you decide or are forced to investigate the North Pole sexist allegations, what do you need to do to make clear when interviewing North Pole employees?
You don't represent them.
Exactly, okay? Right. So, the answer, the Upjohn warnings. You're all familiar with the Upjohn case. If you're not, get it, read it. It goes through in detail right here up front. So if we go to the next one, it talks about what the Upjohn warnings are. You have to advise them that you represent the company, you do not represent them individual. You've got to make sure you say that. You've got to make sure, so you're keeping the privilege in place here, that you're talking about the fact that the company has requested legal advice from you, and as part of your investigation, you are employing them because they have information that may be important to the legal advice that you're giving to the company. You guys wear so many hats. When you're wearing the business hat, when you're wearing the legal hat is difficult. If you go through this and make sure you're going through it each time, you've got the cover to be able to say, I advised them, they were aware of it, this was to obtain legal advice, this is a privileged communication. So the commute privilege is going to cover, of course, the communications between the attorney and the employee. But remember that privilege, of course, is owned and controlled by the company. The company has the right to choose to waive that privilege. So even though you've done everything possible to protect the employee, i.e. the president, if the company now decides it's in the company's best interest to waive that privilege, now you have to tell the president of your company, yes, what we talked about was privilege, but it's not your privilege. We have now disclosed this to the appropriate authorities. The Jerry Sandusky case out of Penn State University, you'll remember there was sexual harassment accusations against the coach of Penn State, and the president of the company and the president of the university and other executives within the university got caught up in this. They were all under the impression that the general counsel was representing them. She told them, what you tell me is privileged. She represented to them that she was representing them individually as well as the university. University then decided to waive the privilege and turn over everything. They sued her for malpractice because she had advised them that she was acting as their counsel when she in fact was not. That summary judgment on that got thrown out. Initially, she got out by summary judgment. She's back in it again, and that case is still proceeding against her individually. So you got to make sure that you are not only creating the privilege and protecting it, but make sure that you're advising your presidents, your executives, that you're not representing them, and this is the company's privilege to protect and waive. And they don't have the right individually to waive it either. All right. So during the investigation, should you request that witnesses execute a confidentiality agreement, that they will not and cannot disclose anything that's discussed with you? No, and it really, that's right, because there's two aspects to this. One, is it enforceable? I mean, you're going to tell him or her not to say anything to anybody. Now you get into litigation. I was told I had to keep all this secret. It looks horrible for you from a practical standpoint. From a standpoint, one, I don't think it is enforceable because they have a right to counsel. They have a right, and you're going to tell them you have the right to your individual counsel. And so they have the right and need to be able to seek their own counsel. And if you've told them they can't talk to their lawyer, now you're interfering with their rights. If you're dealing with employment situations and employees, that's the other part that you raised. If you're telling them they can't talk about conditions of employment, now you're interfering with their right to discuss their employment conditions and circumstances and getting into employment law matters as well. So it's really nice to be able to talk about that and tell them to keep it confidential, but you can't do it from the standpoint of signing a confidentiality agreement. I think it just sets you up horribly. So, yeah. One of the executives, as you're doing your investigation, says, well, I may have sent out some tweets or made some comments that were off color, but it was all in fun. It was off hours. So, yeah, but since you're my lawyer, I want to tell you about this. How do you respond when your president's going to give you very helpful information? And there we go. All right. Yeah. So this gets into who you represent. Remember, since your client is the company, you do not represent the president. So therefore, ethically, the president is an unrepresented party, right? And so now you're talking to somebody who is unrepresented. You need to make sure you're advising them of who your client is and you don't represent them individually. And if they're going to be giving you information that's adverse to the organization, they need to know that they're talking to the organization. You have an obligation to report that information onto the company. All right. So the Rule 1.13 of Professional Rules of Conduct in Texas talks about the lawyer's role, and that there's times when the organization's interest is adverse to those constituents, and that's what the rule always talks about, is the employees, owners of the company who are not your client, always talks about them in terms of the constituent. So if the lawyer finds that their interest is adverse to the organizations, now you've got a conflict of interest between the people you're talking to. And you need to advise them that they may need individual counsel in this situation because your client's the company, these interests may be adverse, so I'm advising you to go get your own independent counsel. Now, we deal with this as outside counsel all the time because we're out there doing the investigation of the cases for you and we're contacting witnesses and so forth. So it's easy for us. It's really difficult when you're sitting there in the executive suite with the person who signs your paycheck, telling them, I don't represent you, I can't advise you. But it is so critical for you to be able to do that for exactly the same reason like the Jerry Sandusky case. You don't want to put yourself in harm's way here. I know my old criminal law professor told me that if it becomes clear that somebody's going to jail, make sure it's your client and not you. Great rule for criminal law, for in-house counsel practice. You want to make sure that you're not putting yourself in a situation where you're exposed on a malpractice because you're answering to the executives of the company. All right. What do you do in a situation where you are giving advice you decide there's no conflict between the president and the organization? Now you're in a situation of dual representation. You need to make sure that you're giving the instructions to that client. If you decide there's no conflict, you represent them both, you've got to talk about dual representation. Same thing when you're dealing with employees in a employment situation where they're your witness, you determine there's no conflict, and you decide you can represent them. If you need, the upfront side of a dual representation, you've got to be able to give them advice with respect to you're representing the company, you're also representing them. Because of the fact that there is no conflict, you can do that. If a conflict arises, you got to talk about what's going to happen there. Now, here's the real tricky thing that we run into all the time. And I've got it coming, it has to get addressed before mediation tomorrow. We have an employee whose interests were exactly the same as the company. Now, the other side made an approach and made a settlement offer to one party to turn state's evidence on the company. Now, while their interests were perfectly well aligned, now they're not. What do we do as lawyers in that situation? We don't run into this as much in outside situations. I think in-house you're going to run into it much more frequently. Once that conflict arises under the rule, you cannot represent either party unless you've got consent. Now, that's a really hard time to get consent. So what you really need to do, and what I always try to do, is get consent up front. You understand that we represent the company. The company is our client. That's who has hired us to retain this. We can represent you. We go through the upjohn warnings, right? And we tell them, we can represent you so long as there is no conflict. The company doesn't see one. I've investigated. I don't see one. And you want to ask the person, do you see any conflict of interest between you and the company? And you got to explain what that means because they don't know. Is there a situation where your interests are adverse? And go through all that. I always make sure to get it in writing, and you guys really need to get it in writing because nobody will remember it if it's not. When you get to that conflict situation that says, if a conflict arises, then we will withdraw from representing you, but you agree that we can continue to represent the company. If you don't get that waiver up front in writing at the very beginning, I don't think you're ever going to get it at the end when they realize they've got supreme leverage over the company because they can deprive the company of its lawyer and deprive the company of its in-house general counsel or head of litigation or whatever your position is in that. And now you have to tell the company that you can't advise the company on this major piece of litigation because you talked to the individual employee as their lawyer. So very, very important to get that in writing up front. Okay. All right. So with that, let me turn it over to Joe to look at some of the corporate transaction-related issues you run into.
So let's go ahead and flip to the first slide here. First question is, what ethical considerations should an in-house counselor weigh when asked to provide concurrent representation of the company and a subsidiary? Any thoughts on that one? You don't have to list them all, but if you have a couple, you might get a prize for it.
Sometimes there's a conflict of interest.
Right. Conflict of interest is the main issue that we're thinking about here. There's a handful of questions we can ask to try to inform that analysis. The first is, do we have shared ownership? Is the parent and the subsidiary owned by the exact same people or entity? If so, that may assuage a little bit the concern that a conflict may arise. Another is the solvency of the companies. You know, are they on strong financial footing? Or do we have a situation where one may be at risk of, if they go into a joint venture agreement, for example, defaulting and not being able to honor its obligations? Third point, there are the interests of the parties aligned. Are they sort of, is the transaction one where they're working together toward a common goal, or not? Is it a joint venture situation where it's actually, we may be working toward a common goal, but we have completely disparate obligations under the agreement, and we're essentially negotiating with each other to arrive at that common end or to achieve that common goal. So the takeaway here really is that if we don't have common ownership, or if we don't have kind of common purpose, obvious common purpose where our interests are going to be aligned all the way, your best bet is just to punt as to the subsidiary and say, okay, let's get separate counsel for the subsidiary, so that you don't get into a situation where your obligations to the company, to your employer, are somehow limited or compromised. Okay, we're going to shift gears here over to some M&A deals, and thinking through what happens to privilege in the context of an M&A transaction. And initially, I want to talk through stock deals and mergers, separate and apart from just asset deals. But in stock deals and mergers where everything is going over to the buyer, okay? So the question is, do privileged communications of the seller pass to a buyer in a corporate M&A transaction?
Yes.
Yes. Give this man a prize. Generally, yes. Generally, the privileged communications of the selling entity will pass to the buyer in the transaction. Now, it gets nuanced, and there's different approaches that different states have taken, which we're going to walk through here. Typically, it's in the second sentence here, typically privilege as to the actual transaction details. If I'm representing you in the transaction and we sell, well, our discussions and our, negotiations relating to the actual transaction are separate and don't pass with the kind of larger general communications privileges that have kind of, been with the business for over a period of time. So in Delaware, a statutory merger, as it says here, the target's privilege transfers to the buyer as a matter of law, okay? And in the parties, as it says there, the parties can and typically do negotiate for kind of the nuances like the transaction details and stuff like that. In Delaware, you have kind of broad flexibility, if you will, or authority to negotiate what privileged communications you want to pass and which ones you don't. So depending on which side of the transaction you're on, there may be a reason why, as a buyer, you say, well, hey, we really need that information going forward to protect us against liability or future claims, stuff like that. But there may be a reason why, as a seller, you want to keep certain communications, with the selling entity and not pass those along. Now, in last year, in the DLO Enterprises case, the Delaware Chancery Court clarified that with respect to asset deals, where we're just selling assets, right, that this general rule doesn't necessarily apply, okay? If you're just selling assets, the privilege and everything doesn't pass along with that. It's really just the mergers, where your company is being subsumed into the acquirer, or a stock deal where the entirety of the business is being sold. So we can move on from that one. Sticking with the same concept here, what is the practical practical consequences test with respect to privilege. This applies in the M&A context as well. Anybody have any thoughts or knowledge on that? It's pretty intuitive, right? It's basically the general business communications transfer to the new owner, the acquirer, if the practical consequences of the transfer of the transaction in both the transfer and control of the acquired business and the continuation of the acquired business under new management, okay? So if we're sending everything over and it's going to be under new management going forward, sort of the practical implication is that, yeah, that acquirer acquired the privileged communications. So that's a test that you'll see a lot of states have sort of adopted that test, that practical implications test or practical consequences test, to sort of determine how to delineate privilege and whether or not it passes. Now, interesting case here that I'll tee up for you, the Techniplex case that came out of New York back in the mid-90s. And just to set the stage for you, Techniplex was owned by a single gentleman, Mr. Tang, entered into, well, and let me back up. The company and Mr. Tang were both represented by a law firm out of New Jersey, Minor and Landis. So, and they represented on environmental matters specifically, okay? Fast forward, the company enters into a big, $40+ million merger transaction with TP Acquisition Co. was the name of the acquiring entity. And the acquirer has a claim for indemnity for a breach of reps and warranties on environmental rep, okay? And so the acquirer, Techniplex, makes its indemnity claim. They go to arbitration, and then they seek to disqualify the law firm from representing Mr. Tang, the sole shareholder, okay? And Mr. Tang says, well, we had dual representation. They were my attorneys. We got an engagement letter individually and all this stuff. And so the New York court comes and has to do an analysis of whether or not the law firm should be disqualified from representing Mr. Tang. And ultimately, they determined that, yes, the law firm has to be disqualified from representing him because in the transaction, the company's privileged information, right? The company has a right. It's the company's information transferred to the acquirer, okay? So now the acquirer owns that information and is bringing an indemnity claim against the seller and kind of indirectly Mr. Tang to recover for the breach of the reps and warranties. And ultimately, that's what was determined. That the business was being continued, new management, and in the court, I think the key holding was that the authority to assert the attorney-client privilege passed to the new corporation, and the law firm should be enjoined from disclosing any environmental-related communications to Mr. Tang individually. So interesting case, for sure to just kind of keep in the back of your mind, particularly when you get into that situation where it's, company and then employee or ultimately who owns that privilege. So considerations given to privileged communications in the context of a bankruptcy or a winding up, and also in connection with a, what was my other point? Oh, yeah, bankruptcy or then a winding up situation. Any thoughts on this one? It's not the best phrased question to try to get you to the answer, so I apologize for that. But so in a dissolution context, right, your privilege typically expires when the company dissolves. And now, that doesn't necessarily mean when we file our, articles of dissolution. But when the winding up process is completed, typically the privilege goes away and the ability to assert it is sort of gone now. And this is a real interesting case out of Colorado a couple years ago, where they went through and really tried to analyze, this issue across states and across federal jurisdictions to try to get a sense, because it was a case of first impression in Colorado, to try to get a sense of, well, gosh, where should we come down on this? And so the background on that case was you had an outside attorney, a gentleman named Fellman was his last name, who represented a company who was trying to raise capital, start a business, okay? And as part of his representation, he drafted an opinion letter, okay, that was relied upon by Affinity Colorado, a private equity group, I think it was, some source of capital at the end of the day. So EagleNet was the company that he represented, that Feldman represented. They went and got capital from Affinity Colorado and relied on his opinion letter to do that, okay? Well, things don't go well with the business. Ultimately, it dissolves and there's nothing left. Affinity sued the business initially, no cash there. And so, they're looking to recover something, so they look to the attorney, they look to the opinion letter and say, there's misrepresentations in your opinion letter, and, we're going to sue you and try to recover. They want to get some money out of the deal. And so Feldman then responds and says, well, hey, it's privileged communications, I can't disclose those. And so it goes up to the appeals court in Colorado. And ultimately, they held that the corporate attorney-client privilege expired when there were three key factors. It expired when the corporation dissolved. There was no ongoing dissolution proceedings. I mean, it was dead. That was kind of the term they used. The corporation was dead. And then there was no longer anyone with any authority to invoke or to waive the privilege. And so the communications had to be disclosed. That's an interesting thing to think about. And one of the arguments that Feldman made in the case was, well, hey, in Colorado and in most states, even though a company is dissolved, it can still be sued. So it seems to be a bit of a disconnect. If I can still be sued, but the company's dissolved and I have to disclose my privileged information, and the court, he made that point, but he didn't brief it up or really develop it. And so in the court's opinion, it acknowledged that argument, but it said that it was not developed, and so they didn't really kind of go down and analyze it. But that's something that I think in the future that will probably develop to where, there's somehow a way where we can, I guess, preserve the ability to object or to preserve the ability to keep the privilege intact if there's the prospect of future litigation. So I think that's an area that's going to need to be developed in the law. And then bankruptcy, this is one, generally just a quick point on this. The trustee, when the control of the company has been relinquished in a bankruptcy and the trustee now has the reins, the trustee then controls the privilege and can waive the privilege. Okay, one more here for me. And of course, we'll leave. Then we could have done the whole presentation on this today, but we're just going to just fly by it, which we try to do most times because it makes our head hurt. The first question here is does Section 205 of Sarbanes-Oxley even apply to me, right? Do I represent an issuer? Do I practice before the SEC? These sort of factors to determine if you even need to worry about it. A lot of folks don't, and so you can rest easy. But if you are, if you do represent an issuer or you advise on matters of, SEC rules or regulations, you fall under 205 and you have an obligation to report in three specific instances to either the chief legal officer of the company or the CEO of the company. And so the key violations or the instances where you have that reporting obligation are a material violation of federal or state securities laws. So if you come upon that situation and realize that that's occurred, then you've got to report it up to your chief legal officer or the CEO. A similar violation of federal or state law. So this is really any violation. It's written so broadly. You need to report it. And then a material breach of fiduciary duty under state or federal law. Quickly the up the ladder reporting obligations. I'm sure a lot of you are familiar with the term, but it's essentially that if you've made that initial report to the CEO or to the CLO and a reasonable time has passed and no action has been taken, then you got to go up the ladder. And that typically means to the board or to a board that's wholly independent. So there's your quick nuts and bolts on Sarbanes-Oxley 205.
All right.
With that, I'll kick it back over to Blake.
Let me
Go back to one point. I told you I was going to cover this earlier because it comes into the Sandusky case too. But when you're dealing with the question right before the last one of who owns the privilege and what happens when a company is winding up, we do see that Texas law, of course, also provides that you can sue a company after it's within 3 years after it's been dissolved. And the question is, who can act for it, which is always a tricky question. But I don't know if any of you guys been following the Elizabeth Holmes, not Elizabeth Smart, that's going back, Elizabeth Holmes with the Theranos. Are you familiar with the situation? She formed this company that says they could, with 1 drop of blood, could do 1,000 blood tests. And that they had she had military people on her board. One of the guys from the Joint Chiefs of Staff, one of the top generals, said that they were using this technology on medevac helicopters in the military. And of course they weren't. The stuff didn't work. They were taking the blood and sending it off the old-fashioned way. So the whole thing's a fraud. She's on trial right now. I think they arrested this last week. Closing arguments maybe today or tomorrow when they're starting. But she testified for several weeks. Anyway, she founded this company. She controlled it. It was everything. She hired David Boyce to represent her in the company. And then the company gets taken over, and new management is handling it, and they've waived the privilege. So she's got all these communications between her and David Boyce. She objected to their admission. The judge said, nope, it's not your privilege. The company has waived the privilege. And so all of these documents are now fully admissible and went in before the jury of all the conversations that she had had. The really interesting thing to me is a son who does advertising. Hopefully, he just graduated with a degree. It was the marketing people that I don't know if you guys have seen that. The marketing people said, well, you're saying that you can do 1,000 tests on a drop of blood. Where are these 1,000 tests? What are the 1,000 tests? Because we can't put it in our advertising if you can't prove to us that you're doing it. So that's really where a lot of this came to fruition and came out, was the marketing, with their due diligence, found out that you couldn't actually support it. But side note on that, also brings up some issues with respect to disclosures. But from an ethics standpoint, from an in-house counsel standpoint, who owns and ultimately owns the privilege can really around on the owners of the company and the officers of the company. So you've got to really make sure those warnings we talked about earlier were being covered. Okay, I'll stop digressing. All right, reasons to keep you up at night as in-house counsel. First question comes up to license and where you're licensed to practice law. Do corporate counsel need to be licensed in each state? Practice only advise the client from the corporate home office. Sorry? No. Okay. Exactly. Now, you guys all practice in Texas. You know this rule well. In Texas, the rule is different. There are many states that have a rule for in-house counsel that says that as long as you're just advising the company from your home state and your home office, that you're authorized to advise them no matter where their practices are. Texas Rule of Professional Conduct 505 says the lawyer shall not practice law in a jurisdiction where doing so violates the regulation of legal profession. Or, and this is where you get in more trouble, assist a person who is not a member of the bar in performance of activity that constitutes the unauthorized practice of law. So Texas is real clear, and this is real simple. You can't practice where you don't have a license. The difference is Texas does not recognize the ability of in-house counsel to be practicing with a license from a foreign state. So the question is how to gain admission. I assume most of you are all Texas lawyers. This may not be an issue, but the Texas rule is uniform bar exam score, which came up after I took the bar exam. But a 270 within 2 years, they'll accept. Or if it's been 5 years since you've had the bar exam, they will accept that score if you can show that you've been in the active practice of law for 2 of the last 3 years. Interesting question, interesting policy statement they've come up with is in-house counsel. They recognize, of course, as active practice of law, but they do make you sign, and everybody has to sign, a verification that they've not violated the rule against practicing law outside the jurisdiction. So you can't cure this after the fact. Make sure you're clean on that. And make sure that the lawyers you're supervising and people you're advising are also licensed. So if you get a multi-state practice, you may just be practicing in Texas, but if your company has operations outside of Texas, be very careful to make sure you're keeping your nose clean on this. All right. It was the whole group said yes. There you go. All right, so the next question. What restrictions, if any, do you have in negotiating your compensation package as in-house counsel? Boy, lots of quiet on this one. You liked practicing law without a license. But you start thinking about who's your client, right? Any restrictions? You're free to negotiate with your company? You're not free. We're going to just stay right on the fence. All right. I'll give you a pass. When you're negotiating your deal with your client, it's a business transaction, right? That you're entering into individually with your client. You know I can't come and enter into a business relationship with y'all, but when you're acting in your own individual capacity, negotiating your compensation package, you are negotiating for a business transaction with a client. Interesting question, who's representing the client in that negotiation, right? It can't be you. So when the president says, draw me up a contract, how do you protect yourself? Okay. So when you do enter into the business transaction, it's got to be on terms that are fair and reasonable to the client and fully disclosed. The client has to be given a reasonable opportunity to seek the advice of independent counsel, which they are going to refuse to do because they pay you to do that. And the client consents in writing. So it really, really is a good idea when you're negotiating your own deal, put the terms in writing, let them know, look, in this situation, I negotiated my deal. I'm not acting as your lawyer. If you want legal advice, you'll have to get it from somewhere else. And get them to consent to the terms of that deal in writing and put in writing that you've told them to get their own counsel on it. Now, the deal that you structure, how good can you negotiate your own deal? Now, this we all point to plaintiffs' lawyers and guys like me on the defense side because you don't like my fee and argue about it. But it also comes into play in negotiating your own deal in-house. A lawyer shall not enter into an arrangement for, share, or collect an illegal fee or one that's unconscionable. Well, no in-house counsel is getting paid unreasonably, right? But it's viewed not only from the standpoint of when you enter it, but when you leave. Now, where this comes into play, to me, and where I see it the most risky, is stock options, especially in a startup company. But you negotiate a deal for stock options that the company explodes, turns into a great, great deal later on. Are you subject to those stock options or grants of stock being considered an unreasonable fee after the fact? I think where it comes into play is when the company is sold, right? You've got new owners coming in, the new people are looking at it, you've got a parachute deal like the executives do, and you're getting a significant fee or a significant payout on that stock. Can the new owner, which now, as Joe just pointed out, owns the privilege and owns the rights and the claims of the company for malpractice, can the new owner come, the buyer come back and challenge your fee and say, hey, wait a minute, this was not reasonable? Again, protection is always done up front. If you've gone through in that prior negotiation, set this out, advise them, look, I'm not negotiating this. This is a transaction between you and me. Get your own counsel. You consent to the terms. Now you've got that documented. So when the new owner comes in and tries to challenge your fee, that you're going to be clean and protected up front. So again, we always, in writing up front, this is again an area where it's going to help protect you down the road if there is any challenge to the fee. So be careful. You're entering into a business, just keep in mind that you're entering into a business transaction with a client, and a client which is now not represented and may think you are. So everything we talked about before comes into play. All right. Now, ethical duties as an attorney in negotiations with third parties. What ethical duties do y'all have when you're dealing with third parties? Negotiate the best deal you can? Yes. Biggest key. Absolute biggest key. You've got to be honest, right? Mere puffery, those types of things that we're used to, courts all allow that. But you cannot misrepresent, you said it exactly right, you cannot misrepresent a material fact. And you've also got to, you can go ahead and flip to the answer. And you also have the obligation to supervise those underneath you, right? So make sure that those attorneys, staff members under your supervision and employees are not misrepresenting material facts as well. We're the only ones with the ethical duty as lawyers. Our business partners don't have the same ethical duty, but they could get caught up in a misrepresentation issue. But if you're running the negotiation, I think there's a real risk to us as lawyers, you guys in-house and us outside, when you've got business people who are overstating or misrepresenting material facts. So you don't have an ethical duty to make sure that the business people are necessarily operating correctly. But if it's under your supervision, I think it may come back to you, and certainly our staff, our paralegals who are negotiating deals, our lawyers that are under our supervision. You're going to have obligations with respect to them too. And again, it comes up with communications with persons not represented, right? If you're negotiating a deal wearing your business hat, and you're negotiating with somebody at an opposing party, different company, are they represented by counsel? Are you as a lawyer allowed to negotiate with another company when you know that other company has counsel? I have seen it asserted that the general counsel of the company has come back in and say, wait, I am general counsel of the company. You know that I represent this company. You know they're represented by counsel, and accusing the party of being involved in the negotiations, of negotiating with someone who is represented by counsel without going through that counsel or getting that counsel's consent. If they don't have general counsel or outside counsel, now they're an unrepresented party, and you run into those issues as well. So again, in negotiations, these same ethical obligations of dealing with represented, unrepresented people are going to come up as risks to you as well. What are your obligations when a constituent makes decisions harmful to the organization? Not necessarily illegal, but harmful. Do you have obligations? If you know that someone within the company, one of the constituents, is taking action harmful to the organization itself. Rules of Professional Conduct 1.12 in the comments says, in most instances, a client has the right to make bad decisions. I'm paraphrasing. Even decisions that are detrimental to the company. So I'm really glad this is in the rules for us. It gives us a lot of protection that we don't have the obligation as counsel for the company to be in there controlling and saying, look, this is bad for us, you need to stop. They're the president, they're the officer that has the authority. If they make a bad decision against the interest of the company, it does not raise an ethical obligation to you. Unless the decision is within the scope of the lawyer's authority, and this is, again, the key word where I like the and being there, is a violation of law or a legal obligation to the organization. So in that narrow instance, the obligation comes back that you must take reasonable remedial measures. And again, that's only if it is a violation of law and it's within the scope of your representation, what you're doing. So the next question is going to become obvious. What are reasonable measures? So when you do have a reporting obligation, Joe talked about the up the ladder reporting. I'm going to ask the question, what are the obligations to take reasonable measures to report up the chain? Nobody? Where do you go if you go up the ladder? If you've got somebody who is doing something that you feel you've got an obligation to report and take remedial measures on, where do you go? First step you can take is to request them to reconsider the action that they're taking. Just deal directly with them. You don't necessarily have to go to their boss or your boss. Confront them directly about it, saying, hey, this is not in the best interest of the company. It's exposing us to this. You need to really think about this. I'll tell you where this came real, very, very real to me. The company that I was representing, the founder of it was the main person I'd represented and was contacting me for years. He'd pass it on to the vice president, take over managing all the legal representation. We continued on for years. This is a client I'd represented for probably 5 years. And I got a phone call, and you guys get these too, I know. But I got a phone call from the vice president of the company saying, now, Blake, do you represent the company or do you represent the president? That question right there. Yeah, you've got the same reaction I did. It's like one of those, oh no moments, okay? I knew the answer, but I also knew the results. And for me, it's easy because I could simply know to tell my secretary it's time to box up these files because we're going to be sending them on. For you all, you don't want to have to be in a situation where you've got to box up the files that are your office, okay? So this is what I did, the same thing you guys need to do. Talk to them and ask to reconsider. How else can you address this issue with the president? What's the issue? Is this really something you need to go to the board? And you give the advice. Look, here's the steps you have to take. You go to the board, you can have the president removed, they can have a vote. You go through those steps and make sure you're giving the proper legal advice. But the practical advice is there too. Is there another way? Have you talked to the president about this? And have you looked at it? So if you go to the person, talk about it, possible ways to reconsider their action, do something different, explaining the consequences of their action. Good, right? Just normal, good lawyerly advice to the person.
Blake?
If that doesn't work, you have to go over the head. You can't just sit there and allow this to sit on your desk in your area of responsibility. If they won't do it, go over the head. And I don't have any problem, I think, in that situation. You may want to simply tell them, look, I think you really ought to reconsider. If not, we need to talk to your boss about this situation. If you can go back a slide, that'd be great.
Blake, we have a question online.
Yeah.
I'm going to read it out loud. It says, practically speaking, how do you protect the privilege that is not being transferred, assuming access to buyer of emails, files, et cetera?
I'm sorry, how do you protect a privilege?
That's not being transferred. I guess this is for an
Okay.
M&A transaction, assuming access to buyer of emails, files, et cetera.
Well, if the transfer of a company is being transferred as basically as a stock sale, you're transferring all the assets of the company, it will be transferred. And and you can't stop it. That's just the nature of the transaction. So all of the privileged information goes to the new buyer and is now within their control. If you've got an asset type of purchase where you're only transferring certain assets and that privilege stays back with the company, then it does stay within your control. I hope that answers. Did you want to add to it?
I suspect that you're trying to drill down and actually understand, in the actual transaction, in the deal document, do we have language that speaks to the privilege and what's passing and what's not passing? And the answer is yes. Technically, you negotiate that point and you spell it out in general terms, obviously, as to what's passing or what's being retained, depending on what side of the deal you're on, obviously. If there is a situation where you need to kind of hone in on that issue.
The question is, what do you do in a situation when you've got a salesperson who is going beyond mere puffery and in making material misrepresentations with respect to a transaction? You're the lawyer papering that transaction. You know they're making misrepresentations and going forward with the deal. What do you do as an attorney in that situation? I think you've got to confront them. And they don't, like you say, they don't want to give up their sale. They all know that we are the obstacle to the salespeople getting their job done. You're the ones that are saying no to everything. But that's our job. We've got to stand up and we've got to make sure that if it is a material misrepresentation that is going to expose the company, and that's where the line is for you, is this a material misrepresentation of fact that constitutes fraud, right? Constitutes a material misrep that is going to expose you to a claim. And while the salesman wants that, salesperson wants that sale closed and wants the commission, we've got to stand up and say, look, we can't make misrepresentation. We will get sued over this, and that creates exposure for us. And, right, they're not authorized within the scope of their authority as an employee to make. So now you have a conflict of interest with the employee, and I tell them, but I think you're free to tell them, this creates legal liability for the company. It creates personal legal liability to you, because if you're making misrepresentations done, now you're acting outside the scope of your authority. I can't advise you individually on that, but I can tell you from the company standpoint, you're exposing both the company and you. So we have got to make sure that representations are factual and they're supported. They hate that advice. It's the right advice.
Yeah.
If they refuse, I don't care, it's my sale, you can't tell me you're just the lawyer. We're in the business of making sales. We're not in the business of dealing with legal issues. Nobody's heard that, right? Yeah. Now it's up the ladder reporting time to me. Then you've got to go to their supervisor. You've got to go to your supervisor. You've got to go to an officer of the company and say, look, we have an issue. I'm concerned about, I know it's an important sale. I'm concerned we are exposing ourselves to suit because these misrepresentations were made, and we either have to back them up, like the marketing folks in the Theranos case, back them up or withdraw them. And the marketing folks in Theranos, I really admire them for doing it. I can't believe it was the marketing people that busted this massive fraud. But that's the thing. Look, if you're going to say this, show me where it is. Show me where we can say this. If we can't say it, I can't have it in the deal. And that's where you have to do the up the ladder reporting. Your supervisor, their supervisor, whatever it takes to make sure that it's reported. And how do you want to report it? In writing. Good. Well, thank you all. We really do appreciate and value the relationship we've had with the ACC for years. Like I say, we're active in the Florida chapters as well as some of the Gulf states in between. So we are a huge supporter and fan of the ACC. It's hard because we don't get together with you guys that much, with a few times a year. But we're always available if there's ever any questions. And I really do mean that sincerely, and Joe as well. If there's questions and issues come up, say, hey, you guys talked about this, or we've come up with this issue. We are always open to a phone call and questions and being able to chat. We've had relationships with a lot of you over the years, and several of which I know are online today too. So, yeah, anything we can ever do to help you, please don't hesitate to give us a call. Any questions afterwards, we'll stick around. We haven't eaten yet, so we'll be here. So good. Thank you all.